5. Article 61. Why in news? Since the impeachment proposal of USA's president was made, Article 61 related to Indian president also becomes important. About Article 61. Procedure for impeachment of the president. 1. When a president is to be impeached for violation of the Constitution, the charge shall be preferred by either House of Parliament. 2. No such charge shall be preferred unless the proposal to prefer such charge is contained in a resolution which has been moved after at least 14 days' notice in writing, signed by not less than 1/4 of the total number of members of the House has been given of their intention to move the resolution, and b. Such resolution has been passed by a majority of not less than 2/3 of the total membership of the House. 3. When a charge has been so preferred by either House of Parliament, the other House shall investigate the charge or cause the charge to be investigated, and the President shall have the right to appear and to be represented as such investigation. 4. If as a result of the investigation a resolution is passed by a majority of not less than 2/3 of the total membership of the House by which the charge was investigated or caused to be investigated, declaring that the charge preferred against the President has been sustained, such resolution shall have the effect of removing the President from his office as from the date on which the resolution is so passed. Sections related to laws that were in news. 1. Section 144 of CRPC. Why in news? It has been imposed for reasons ranging from Northeast Delhi riots to COVID-19 pandemic management. About Section 144 of the Criminal Procedure Code, CRPC, of 1973 authorizes the Executive 5. Magistrate of any state or territory to issue an order to prohibit the assembly of 4 or more people in an area. According to the law, every member of such unlawful assembly can be booked for engaging in rioting. Section 144 is imposed in urgent cases of nuisance or apprehended danger of some event that has the potential to cause trouble or damage to human life or property. Section 144 of CRPC generally prohibits public gathering. Section 144 has been used in the past to impose restrictions as a means to prevent protests that can lead to unrest or riots. The orders to impose Section 144 have been conferred to Executive Magistrate when there is an emergency situation. Section 144 also restricts carrying any sort of weapon in that area where it has been imposed, and people can be detained for violating it. The maximum punishment for such an act is 3 years. According to the order under this section, there shall be no movement of public in all educational institutions shall also remain closed, and there will be a complete bar on holding any kind of public meetings or rallies during the period of operation of this order. Moreover, obstructing law enforcement agencies from dispersing an unlawful assembly is a punishable offense. Section 144 also empowers the authorities to block the Internet access. 144 CRPC bars the conduct of certain activities or actions or events which are allowed to be done in regular course. It is imposed to ensure maintenance of peace and tranquility in an area. Duration of Section 144 order. No order under Section 144 shall remain in force for more than 2 months, but the state government can extend the validity for 2 months and maximum up to 6 months. It can be withdrawn at any point of time if situation becomes normal. Representation of People Act, 1951. Section 8(1). A person convicted of an offense punishable under certain provisions of Indian Penal Code, Prevention of Corruption Act 1988, etc. shall be disqualified from contesting election. 6. Section 29A. Registration of political parties is governed by the provisions of Section 29A of the Representation of the People Act, 1951. A party seeking registration under the said section with the Commission has to submit an application to the Commission within a period of 30 days following the date of its formation in prescribed format with basic particulars about the party, such as name, address, membership details of various units, names of office bearers, etc. 2. Section 124A of IPC. About the Indian Penal Code defines sedition, Section 124A, as an offense committed when any person by words, either spoken or written, or by signs, or by visible representation, or otherwise brings or attempts to bring into hatred or contempt, or excites or attempts to excite disaffection towards the government established by law in India. Disaffection includes disloyalty and all feelings of enmity. However, comments without exciting or attempting to excite hatred, contempt, or disaffection will not constitute an offense. Under this section, punishment for the offense of sedition. Sedition is a non-bailable offense. Punishment under the Section 124A ranges from imprisonment up to 3 years to a life term, to which fine may be added. A person charged under this law is barred from a government job. They have to live without their passport and must produce themselves in the court at all times as and when required. 3. Section 188 of IPC. Why in news? This section is used to book a person violating COVID-19 lockdown. About. Section 3 of the Epidemic Diseases Act, 1897, provides penalties for disobeying any regulation or order made under the Act. These are according to Section 188 of the Indian Penal Code. Disobedience to order duly promulgated by public servant. 7. Section 188, which comes under the Code's Chapter 10, of Contempts of the Lawful Authority of Public Servants, reads: Disobedience to order duly promulgated by public servant. Whoever, knowing that, by an order promulgated by a public servant lawfully empowered to promulgate such order, he is directed to abstain from a certain act, or to take certain order with certain property in his possession or under his management, disobeys such direction, shall, if such disobedience causes or tends to cause obstruction, annoyance or injury, or risk of obstruction, annoyance or injury, to any persons lawfully employed, be punished with simple imprisonment for a term which may extend to 1 month or with fine which may extend to 200 rupees, or with both. And if such disobedience causes or tends to cause danger to human life, health or safety, or causes or tends to cause a riot or a fray, shall be punished with imprisonment of either description for a term which may extend to 6 months, or with fine which may extend to 1,000 rupees, or with both. Explanation: it is not necessary that the offender should intend to produce harm, or contemplate his disobedience is likely to produce harm. It is sufficient that he knows of the order which he disobeys, and that his disobedience produces, or is likely to produce, harm. Important doctrines in news. 1. Doctrine of proportionality. Why in news? Recently, Supreme Court has delivered verdict on a bunch of petitions challenging the restrictions imposed on internet services and movement of people in Jammu and Kashmir. About. The concept of proportionality is used as a criterion of fairness and justice in statutory interpretation processes, as a logical method to assist in discerning the correct balance between the objects of a legislation and the means adopted to achieve them. Doctrine of proportionality is related to the principle of interpretation of statutory provisions, which maintain fairness and justice. It is a kind of restriction for the administrative action or legislative enactments from being drastic, when it is utilized for securing desired results, so that a sense of proportion is maintained between its goals together with preserving public interest with least effect on the 9. 3. Doctrine of essentiality. Why in news? Recently the Supreme Court has decided to refer the Sabarimala temple case to a larger 7-judge bench. About. The doctrine of essentiality was invented by a 7-judge bench of the Supreme Court in the Shiror Mutt case in 1954. It is a contentious doctrine evolved by the court to protect only such religious practices which were essential and integral to the religion. The court held that the term religion will cover all rituals and practices integral to a religion, and took upon itself the responsibility of determining the essential and non-essential practices of a religion. Referring to the Ayodhya case, the Constitution Bench had ruled in 1994 that a mosque is not an essential part of the practice of the religion of Islam, and namaz prayer, by Muslims, can be offered anywhere, even in open. 5. Article 61.